Find my screen glasses, so if it looks like I'm squinting, I'm not being mean. I just can't see. All right, ladies and gentlemen, so this is the criminal motions calendar for June 15th, 2026. I'm Judge Tammy Long Hayward. The first case on the calendar for the 10 a.m. calendar is Diego Aguilar. I have that's a motion to suppress, but that case is closed. Is there anything to hear on that case?
No, Your Honor. Jay Jordan for Mr. Aguilar. I just was going to appear and say that the case is closed now.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, ma'am.
Have a great day.
You too. The next case is Alexis Mercedes Barnes. This is also a motion to suppress. This is for Trav Tao or Toe, Mr. Toe, Mr. Tao.
Good morning, Your Honor. Tao, yes.
Oh, Mr. Tao. Okay, good
Yes,
morning.
we have a negotiated agreement for your consideration.
I'm ready if y'all are ready.
I just have to make the appropriate amendment, but I will be ready.
Okay.
1 second.
Ms. Barnes?
You should be on.
Oh, I see. Ms. Barnes, oh, there you are. All righty. Can you hear me?
Yes.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I solemnly swear or affirm any
You can just say yes.
Oh, yes.
Okay, you can put your hand down. So you're before the court on case 2025 CR 07928. You're before the court for DUI less safe, count 1, and striking a fixed object, count 2. Your attorney is here. Sir, what is your client plea to the offenses before the court?
For the amended offense of reckless driving, she pleads nolo if possible, otherwise guilty.
All right, Ms. Barnes, I'm sorry, Ms. Adams, are you adding that as 3 or are you changing the number 1?
I'm changing. I just changed number 1, Your Honor.
Okay, no problem. So as to the amended accusation, reckless count 1, that'll be a guilty plea. Count 2, did you wish to enter a nolo plea to count 2?
Could I do that to count 1 as well?
No.
Okay. Yes, nolo to count 2, Your Honor.
Okay. All right. I enter a guilty plea to count 1, reckless driving as amended, and nolo plea to count 2, striking a fixed object. You give up the rights to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Ms. Barnes, if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis and recommendation, please.
Your Honor, on August 11th, 2024, at approximately 4:55 p.m., officers responded to the life storage located at 303 Highway 138, Riverdale, Georgia, 30274, in reference to a vehicle collision. Upon arrival, officers made contact with a witness who advised that he observed the defendant's gray Honda drive just outside of the parking lot of the life storage. He noticed the car reverse and tried to re-enter the parking lot and then strike the gate access control panel. The witness further observed that she reversed back again and drove onto the bushes, which knocked off her bumper. Officers making contact with the defendant observed the defendant in the driver's seat and the sole occupant of the vehicle, and observed her attempting to start the vehicle and try to leave the scene.
All right. Recommendation?
At the count one, the state is recommending a $300 fine. Count two, the state is recommending a $100 fine.
All right. Count one, $300 fine. So, Ms. Barnes, the $300 fine with the surcharges is going to be $444. I can give you up to 60 days to pay that without putting you on your probation. I'll give you 30 days automatically because you're not here at the courthouse, but if you need more, I can give you 60 days. And if you need longer than that, because I do understand you have two sets of fines and fees, then I can put you on a probation option that all you have to do is report and pay. And as soon as you finish paying your fines and fees, then your probation will terminate. So the count, as to count two, the $100 fine is going to be $153. So we're looking at what, close to $500, $600.
Okay. Can I have 60 days?
Yes, ma'am. All right. So, Miss Barnes, I don't know what was going on that day. Some of us are just having bad days, but you're too young to lose control of your life. Okay. You gotta start making some good choices. Okay. You messed up your car, which I'm sure cost you. And it just really wasn't necessary. I tell people all the time, we have ride share services now. When I was younger, we didn't have that. We had to call a relative. They were probably going to get on us. And, we had to pay for taxis and stuff like that. And so it's a different world that you live in. Take advantage of the world that you live in, because otherwise you're going to cost yourself a lot. And I don't just mean money. Okay.
Okay.
All right. So I'm going to give you 60 days in which to pay. The only thing I need you to do you know how to use the chat function?
No, I don't.
Okay. So do you see chat anywhere on your screen? If not, if you see something that says more, click on that.
Okay, I see it.
Okay. So click on chat,
Mm-hmm.
click on new chat. All right. And you're going to click on Tiki Brown, TIKI.Brown. Does it open a box at the bottom?
I don't see where it says.
Did you click on new chat?
Judge,
Oh,
I sent
yes.
her a message.
Oh, okay. Miss Brown is sending you a message so you can respond to the message she sent
Okay.
you. All right. So what I need is your first and last name and then your email address. Please make sure you check it to make sure all of the numbers and letters are in the correct order, and then send that to Miss Brown. She's going to send you a copy of your sentencing sheet. It's going to give you the exact date by which you need to pay all of your fines and fees. If you wish to pay partially, you can bring them into for the second floor of the Justice Center building at 9151 Terra Boulevard, Jonesboro, Georgia, in Clayton County, or you can pay online or by phone, and that information should be in the email, okay?
Okay.
All right. Did you have any questions?
No, ma'am.
All right. Well, be careful, Miss Barnes. Make better choices, okay?
Thank you. I will.
You're welcome. All right. Mr. Tull,
Yes, Your Honor.
did you have anything else at this time?
That's all, Your Honor. May we be
Oh.
excused.
Yes, sir. Thank you.
You have a good day. Thank you.
You
Bye.
too. Gloria Danielle Billings, Mr. Fry. Is that what's he got going on?
He filed a conflict, Judge, and he said he's going to file a motion to withdraw the motion and speak with the state about a PTI, possible PTI. Call Friday.
All righty, got that. Thank you. Next is Jashawn Augustus Boyd. So this is for an interlock waiver.
Mr. Boyd?
Boyd.
He's present in the courtroom. I'll have him come forward.
All right, come on up, Mr. Boyd. I got a couple of questions I have to ask you for the interlock waiver.
Hey, good morning, Judge. I don't know if you
Good morning. So, Mr. Boyd, raise your right hand for me. You solemnly swear or affirm any testimony you give will be true.
Yes. Do you see?
All right, you can put your hand down. So, Mr. Boyd, the interlock waiver, I have to ascertain that it would be a financial hardship for you. Have you looked at the prices for what the interlock would cost?
Yes, ma'am.
Okay. Do you know about what it would cost per month?
Yes, ma'am.
Can you tell me what that is?
It would be approximately 250 a month, 250 a week now. Between
Okay.
Yes, ma'am.
Look, talking to the red microphone, that's the one that actually works better. Okay,
Yes, I'm
thank
sorry.
you. No problem. So are you working currently?
Yes, ma'am.
Where you working, sir?
I work at Kroger distribution company called BGDC, and I also work at FedEx.
Okay. Are you paying for your rent or mortgage?
Yes, ma'am.
Okay.
Actually, I'm currently getting ready to move. That is kind of the biggest problem right now because I stay so far away from everything. Um,
And you don't
that
have a car, I'm assuming.
I don't have any kind of transportation at all, and
I got you.
I'm constantly trying to get to work, and Uber due to gas prices is going up.
Yes, sir. All right. So I find that the cost at this time in your life, the cost of the interlock device would be a hardship. I don't see that unless the state is going to tell me something different. I don't see that you've had any issues since this case was closed back in 2021. So with that being the case, I'm going to go ahead and grant the interlock waiver. We're going to go ahead and send you a copy of that. And it's a form and we'll just fill it out and I'll sign it. Okay.
Thank you, Judge
If
Hayward.
you have any other questions?
Thank you. That's it.
Okay.
Do you remember me?
I do kind of. Is there an email address that you have that we can send it to so I can give it to you quicker?
JASHAUNBOYD@gmail.com.
So just your first and last name at Gmail.
Yes, ma'am, with a U.
Okay, I got you. I did notice that change and I thought, well, do we have it? So how have you been doing?
I've been doing good. I've been making the necessary changes in life to make sure I'm not seeing you again. I saw you 3 times in less than 3 years. So, and I remember the next time you told me, you was like, "Hey, I need to see
It was
some
going to be
changes."
different.
Yes, ma'am.
Well, you look good. You look like you're making some changes. Anybody with more than one job, I have much respect for because I tell people all the time, my husband had no less than 2 to 3 jobs as long as I've known him existing. So, you always got to get out there and make it happen. So let's see if we can get past this point and eventually get you a car again. Okay.
Yes, ma'am.
All right. Take care,
Thank you, sir.
Mr. Boyd.
Yes, ma'am. Thank you.
All
God
right.
bless.
You too. Cassandra de la Cruz Perez.
You don't have to come up, Ms. Perez.
This is Lester Holton Dennis.
Judge, my trial partner, Mr. Bug, is going to be handling that, but I believe that there is going to be a consent motion to modify, but I'm not sure whether, I think there are witnesses here. If anything needs to be placed on the record. Go ahead.
Okay, Miss Adams, Mr. Bug.
Yes, Your Honor. The state is agreeable to a consent vote in this matter. We do have our victim here to place her wishes on the record.
Okay, if you want to go ahead and do that now, then you all can submit the consent and I'll sign off on it.
Yes, Your Honor. She's actually in the courtroom right now.
Okay, come on up, ma'am. Mr. Bug, if you will give her the podium, come on up and to the red microphone, ma'am. Do we need an interpreter?
I believe so. Let me
Okay.
confirm.
Okay.
All right, good morning, ma'am.
Hello, good morning, Your Honor.
Hi, can you do the red microphone for me?
This one?
Yes, ma'am.
Okay,
That's
good
better.
morning, good morning.
Good morning. What's your name, ma'am?
My name is Anita Orozco.
Ms. Orozco, raise your right hand for me. Do you solemnly swear or affirm any testimony you give will be true?
Yes, sir.
All right, you can put your hand down. Okay, Ms. Adams, your witness.
Your Honor. Ms. Orozco, could you please say and state your name state and spell your name for the record?
Anita Orozco, ANITAOROCCO, Orozco.
And that's ZCO?
C as in zebra, C as in cat, and O.
Thank you.
Oh, sorry.
And you are the alleged victim in this case?
I am Cassandra's mother. Everything happened and occurred in my house.
Are you aware that there's currently a no contact bond condition?
Yeah,
Um,
I know we haven't been together. We can't, and that's why, I need to help my daughter. I need to be with her.
and are you asking the court today to modify that condition?
Yeah, I need to have contact. We need to have contact with my daughter.
Mhm. Has anybody forced you, threatened you, or pressured you at all to make this request?
No,
Do you have any safety concerns regarding having contact with the defendant?
no,
Okay, no further questions, Your Honor.
Ms. Orozco, how old is your daughter?
26.
Okay,
I'm
does she
sorry,
have children?
I have 7 kids.
Oh, no, it's okay. That's all right. Does she have children?
She does. She has my grandbaby and my granddaughter.
Okay, are you helping her with those 2 grandbabies?
I'm helping her with one. We're trying to fight for the other one that he took away from us.
Okay, I got you. All right. So this is a very complicated situation all around. So I'm fine with signing a no violent or harassing contact modification, which means that you can have contact with your daughter as long as her actions do not cause any harassment or violence. I get that there's kind of a lot going on for your daughter, and so sometimes that is what plays into these issues. But I hope that I'm a grandmama's baby, so I hope that you all can find your missing grandchild so that you can reestablish that connection, okay?
Thank you. Thank you very much.
All right, so we'll go ahead and get that signed. Mr. Bug, are you in agreement? Yes, ma'am. You can have a
Yes,
seat.
Your Honor, I'm in agreement.
Okay,
And
so
also,
y'all go ahead and get me the order and we'll get that signed, and then Miss De La Cruz Perez can have contact with her mother.
thank you, Your Honor. Just to be clear for the record, I believe she also would need to be able to remove the stay away from the incident location.
Yeah, that's fine too. Modify both.
Thank you, Your Honor.
Thank you
Okay.
very much, Your Honor.
All right, ma'am.
You have a good day.
Take care of yourself. All right, next is Julie Elder.
Honor, that attorney filed a conflict letter.
Okay.
I saw that one over the weekend.
Also say hold for her. Wanted me to tell you to hold for her report, Judge.
Oh, Miss Berry?
Yeah.
Okay. No problem.
Did file a
Alright.
conflict.
I got you. So Talik Bernard Grant, I see Mr. Grant is here and this case is closed, but my understanding is he is wishing to withdraw his plea. So I think this is the one where we have moved this case a couple of times. Mr. Hicks?
Yes, ma'am.
Yes, sir.
Your Honor, I wish to withdraw the motion, and I think I owe Mr. Grant and the court some explanations.
Okay.
To Mr. Grant.
Yes, sir.
I believe that your prior attorney did not see the videos, but did do the best job he could for you. The videos would not have changed the outcome.
I'm sorry. May I speak? May I say something?
They said the case closed though.
Yes, ma'am.
Yeah.
Go ahead.
We went to the head amount of times and spoke with the
Miss Grant.
Miss
Hold
Rowland.
on. There's gonna be a time when I'm gonna allow you to speak, but if I don't hear out Mr. Hicks, then I don't know, I don't have context for what you're gonna tell me. Okay?
They said
And you can't just
closed.
start talking. We clear? I'll hear
No,
you.
we need to make sure that it's closed because Talik didn't do nothing.
Miss Grant.
No, rolling. I'm rolling.
Can we do this with some order and some respect for the court?
Yeah, ma'am. I'm sorry. I'm sorry, Miss
Okay.
Judge.
All right, so Mr. Grant, it's not for you to apologize. It's just that there's a way to do things, and I will hear Ms. Grant out if she wants me to, even though she's not a party to this case, but she's got to wait until I recognize her after I've heard Mr. Hicks. That's just how it's done.
Yeah, ma'am.
All right, now, Mr. Hicks, continue, please.
To the court, the reason I asked for the video, which took some effort on my part, was that Mr. Grant had indicated that he had stopped at the stop sign prior to making a right turn. I told him that most of the time, police officers don't have their video on until after the incident has happened. But in this case, after reviewing the video, the officer had his video on. What I saw was that Mr. Grant was behind a red pickup truck, which was stopped at the stop sign as the officer pulls up. He didn't move. Mr. Grant, who was behind the pickup truck, goes around the pickup truck, doesn't stop, and makes a right turn in front of the pickup truck. He indicated to me that he had stopped at the stop sign. My reading of the law was that was insufficient to indicate a stopping at the stop sign. And I believe the officer was correct in stopping him for not stopping at the stop sign. So I think that's a proper reading of the facts and the law as I understand them.
Okay.
The
All
case
right.
closed.
Ms. Grant, you had a question?
This issue wasn't really about the stop sign. The issue was about them adding the extra fake charges, the instruction of officer charges, and Mr. Lynch forcing Talik while Talik was in distraught to put a guilty plea in. Talik, I was not present. Me and my sister was on the way. We was running late that day, and we was there to try to advocate for him because Talik been through a lot. He been in and out of hospitals. He got a lot going on psychologically, and he's going to therapy right now for that. So anyway, I believe those two officers, they took advantage of Talik's mental health. They didn't contact me or his dad and let us know that something was going on. We didn't even know he was missing, but they made Talik get out of character, and then they added false charges on him. So I'm glad the case is closed, but that's what we just was getting here. We was just trying to make sure that this gets dismissed because I'm from New York and Georgia got a lot of crazy rules, but I want to make sure that my son is okay and he's not being a victim of the system in Georgia's corrupt things that go on here in Clayton County and every county. That's what I want to make sure. I want to be able to travel and move without having to worry about my 26-year-old son having to having to be stressed out about this.
All right. Since he closed the probation.
She's saying something.
Oh, my bad.
Go ahead, Mr. Grant. What were you saying?
Since he closed, because the probation ended like last month, what's the next step?
There is no next step, sir. If probation ended and your case is closed, you're good to go.
Oh, good to go. Thank you,
Yes,
Mr. Hayward.
So, Ms. Grant, here's the thing. I know your concerns. Your son is 26, which makes him an adult in the eyes of the law. No police.
He's not in his right mind.
Hold on, Ms. Grant. Can you stop for a minute, please? Because I'm a mom of a kid who has special needs, right? And so I'm talking to you. I'm trying to tell you from the perspective of what happens when the police stop someone. If that
Mhm.
person is an adult, they're never going to call that person's parents unless there's something that indicates that they have issues and somebody else should be
Well,
contacted.
listen,
Now,
it was the
hold on, Miss
sorry.
Grant. Miss Grant, please stop. I let you talk.
I got one more thing after
No,
you say that.
ma'am. Hold on. What I'm
It's supposed
indicating
be a
to
red
you
flag
is
pop up for Talik when police pull him over. That means that they were supposed to be alerted that he has mental health issues. To my knowledge, when he was hospitalized a couple of years ago, the lady told me that any police officer that have an encounter with Talik, a code pops up for him. So I'm trying to figure out
ma'am.
how the officers can
I
see
don't
stuff in
know
the
who
computer.
told you that, but that's not true.
Yeah,
I don't
They're
tell,
they
I
can
don't know.
code for mental
I
health
don't know who
people.
told you that, but that's not true.
Mm-hmm. So
So
they supposed to have a code. They told me that that code would follow him.
they who, Miss Grant? They
The
who?
doctors, and
Hey,
when
bro,
he was
that's
in
No,
and out of
ma'am.
the hospital,
No,
benefit,
ma'am.
bro.
There's no code.
in the psychiatric ward.
Look, I was just disagreeing with the I made a
I
step
got you,
in the
Mr. Grant. It's not about your case. I'm trying to get your mom to understand that her understanding of what she thinks happened or should have happened is wrong. There is no code. I'm telling
Well, it's
you.
okay if it's
I've been
wrong.
doing
I'm
this,
trying to
ma'am.
battle with you about that. That's so I don't want you to think that I'm trying to battle with you. It's
You
okay
are.
that it's wrong. That's what I want you to know too. Again, because sometimes we be with Northerners and Southerners. Sometimes they don't see eye to eye.
It's
But I know
not Northerners or Southerners. I was born in New York City. Half my family still lives there. So it's not a Northern or Southern thing. What I'm telling you is, I don't know if New York does that, but
I didn't.
there's no mechanism here for there to be a code in the computer when he gets stopped. All they know is he's a 26-year-old, which makes him an adult, and they will not contact anyone else because he's an adult. And if he's an adult who's driving and has a valid driver's license, then that's who they're thinking. If he shouldn't be driving, then that's for you and him to decide. But if he's on the road and he's driving, then they're going to assume he has the capacity not only to drive, but to deal with those people he would come into contact with, like the police.
Your Honor.
If it's a situation where he shouldn't be driving, then you should take care of that with Mr. Grant.
Yeah, I've been a victim of Georgia police too, so I know how they move. They don't care if you sick, health,
Ma'am, that
mentally.
is
They
not true. That
yeah,
is
they
not
bang.
true. You're making a lot of assumptions that are not
They
true.
took me to jail too, and then had to dismiss the case too because they full of crap. They
Okay,
take
Ms. Grant, I think we've heard enough. Now you've gotten to the point where it's insulting and you're making statements without information. You're making statements on assumptions. Okay, so Mr. Grant, you're free to go. Be safe, sir. Please follow the laws, the traffic laws, and you should be okay. All right.
Well, thank you. Enjoy your day and morning. Good. Have
All
a good
right.
week.
Take care, Mr. Grant. All right. You're excused at this time, Mr. Grant.
Yeah.
Thank you, ma'am.
Yeah.
That's all I
All
have.
right, Mr. Hicks, thank you. The motion is withdrawn and you're excused.
Thank you.
All right.
Good day.
Harold Great.
Judge, that is going to be a negotiated plea today. He is in custody. Should we go ahead and bring him out?
Yes.
Thank you. And I guess I should have probably already asked this, but I believe that count 1 is going to be amended to reckless driving. I'm not sure whether that has happened yet. Miss Adams can probably let the court
Have
know.
you had the opportunity to amend?
I am doing that now.
Okay. Well, when you bring him out and it's amended, I'll
They're gonna she's making sure the charge has been changed to reckless driving, and then the judge is gonna take your plea. Yes, sir. Thank you. And so I believe we're in that. Everything else is gonna be dropped. They gave me another court date for the 22nd. That's the trial date, but because we're taking a plea, that's done with. Thank you.
I amended count one.
I was so confused. Yeah. Was that when you caught the? No. Yeah. Oh, and that triggered the favor. That triggered the BOP. I want that one probation. Oh, so you, yeah, I like the probation, right? You're serving the. Yes, sir. Yes, sir. Yes, sir. Yes, sir. Everyone on the meeting, please make sure your microphone is muted if the court is not directly calling on you.
All right, thank you. Ms. Adams, have you changed the accusation?
Yes, Your Honor, I amended count one.
Okay. Count one would be reckless, is that what it is?
Yes, Your Honor.
Okay, so Mr. Great, Harold Great Jr., you're before the court on case 2026 CR 03486. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
Okay, you can put your hand down. So you're before the court for driving under the influence, but that has been amended to a reckless driving. Count one. Count two is driving with site license suspended or revoked. Count three is no license. Count four is a suspended registration. Count five is failure to amend tag in 30 days. Mr. Lynch, what does your client plead to the offenses before the court?
Yes, Judge, that is going to be a guilty plea to reckless driving, the amended count one, I believe, and a guilty plea to count two, which is driving on a suspended license. And I believe that the remaining charges are null. Let me verify that. I don't want to speak out of turn. But yes, I believe the remaining charges are null prost.
Yes. All right. So Mr. Great, by entering a plea of guilty to reckless driving in the amended accusation, count two, driving on a suspended or revoked license, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis and recommendation, please.
Your Honor, on January 1st, 2026, at approximately 9:40 a.m., officers were working in the area of King Road in Church Street in Riverdale, Georgia, in Clayton County, when they initiated a traffic stop on the defendant's vehicle for expired and suspended registration. Officers spoke with the defendant, who admitted that he did not have a valid driver's license. Once officers ran the defendant's information through GCIC and CIC, it returned that the defendant, in fact, did have an expired registration and that he did not have a valid license. His license was suspended. Officers, in speaking with the defendant, observed the odor of alcoholic beverage coming from him. They observed slurred speech and bloodshot eyes, and they observed the defendant continuously making repetitive statements about the vehicle. The officer subsequently asked how much the defendant had to drink, and he stated that he had a beer early that morning. The defendant declined to take any field sobriety testing, and he declined implied consent. As to count one, the state is recommending 12 months to serve 15 days, credit for the time served. And then the balance can suspend. As to count two, the state is recommending a $500 suspended fine. The remaining counts will be no pressed.
All righty. I'm sorry. Do the reckless one again. I'm sorry.
My apologies.
No, it's fine.
We are recommending 12 months to serve 15 days, credit for the time served, and then the balance can suspend.
All right, and the second one?
We're recommending $500 suspended fine.
And he's done the 15 days. Is that the total?
Judge, I can shed some light, I think, on some of the questions you might have at this point. But he has done the 15 days. He's been in custody. He's been in custody since the arrest, Judge.
Okay.
And he's currently in custody of another jurisdiction for the next 6 months, Judge.
All right, so that works. All right, so Mr. Gray, I'm going to accept your plea of guilty to the amended charge on count one of reckless driving, 12 months to serve 15 days, credit for time served, balance suspended, as long as you have no new violations of the laws of the state of Georgia. Count two will run concurrent with count one. It's a $500 fine, but it will be suspended for credit for time served. Counts 3, 4, and 5 will be no prize. Mr. Great, I don't know what's going on, sir, but we're too old to be spending time in jail. You got me? I don't even know your age, but I can look at you and say that you're not for this life. You got to figure out what's going on, because this is not what you need to be doing at this point in your time in your life. Okay. Right. So whatever's coming next, take that time to start thinking about what is going on in your life, asking yourself some questions, being truthful with yourself about what's going on, and trying to make some different steps. Okay.
Yes, ma'am.
All right. You can go back with the sheriff's office.
Thank you.
Thank you, Judge.
You're welcome. All right, next is Quintez Jamal Hudson.
Judge, I believe that was reset to June the 30th for that show cause hearing. And I had some, I believe that's because of the private attorney's conflict.
But I thought it was reset for this one.
No, it was initially reset to here, and then the private attorney
had a conflict
today. So
yeah.
I believe.
Okay. All right. Tanya Johnson.
Judge, Ms. Johnson is on the call, and I believe we're gonna have a negotiated plea. I will just need to, and I should already be on, but I'll need to do a brief conference with her. But I believe we're gonna have a plea to an amended charge of reckless conduct. I mean, I'm sorry, reckless driving. And if I'm gonna sign on to the meeting, and then if I could do a brief breakout with her, we'll be ready to go forward with that. That's what I anticipate.
All right, the Königsberg case is closed. Is there anything left on that?
No, no, Your Honor, not for the state's knowledge.
All right, Bartholomew Oluwasesan.
Judge, that is actually going to be a negotiated plea. I don't, just to maybe kind of prep the court for potential issues. It's a plea to a DUI with the minimum conditions. Mr. Oluwasesan is going to ask the court to allow him to report via mail or reporting, mail or phone while he's in compliance. He does reside in, I believe it's Idaho or Indiana. I'm sorry, I keep getting them mixed up. I believe Indiana. And I think the state agrees to that. And if that's the case, we're ready to go forward. But I just needed to. I know the court sometimes wants to weigh in on that, and I just wanted to make sure the court was aware.
Considering that he does stay so far, we don't necessarily have an objection. Like I said, we're just making sure that as long as he stays in compliance, or as long as he's able to stay in compliance with the recommendation, we wouldn't have an objection.
I guess, Judge, if the court is okay with that, we can go forward with the plea for Mr. Oluwasesan.
Okay, Mr. Oluwasesan, please raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
True, Your Honor.
All right, you can put your hand down. You're before the court on State of Georgia versus Bartholomew Bay Oluwasesan, 2023 CR 024262 for DUI count 1, DUI less safe count 2, and following too closely count 3. Mr. Lynch, what is your client plead to the offenses before the court?
Just a guilty plea to count 1.
Oh, my apologies. I don't think I made that update either.
Count 1 is going to be a DUI, correct?
You're right. I'm thinking of the wrong person. My apologies.
Yeah, you're thinking about Ms. Johnson. I
Yes.
mean, we'll take it if you want to do it.
I'm thinking about the wrong person. My apologies.
All right, and count 2 will merge, count 3 will be no process. Is that what we're doing?
Yes, Your Honor.
All right, by entering a plea of guilty to count 1, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis recommendation, please.
Yes, Your Honor. On November 21st, 2022, at approximately 3 p.m., officers were dispatched to Highway 85 and its intersection with Lee's Mill Road in Clayton County in reference to a vehicle accident. Upon arrival, officers made contact with the defendant, who was the driver of one of the vehicles, and observed the odor of an alcoholic beverage on the defendant's person. Officers observed the defendant to have red, watery eyes. They additionally observed the defendant mumbling and unable to provide a clear statement. Officers asked the defendant to submit to standardized field sobriety testing, to which he refused. Later on, officers read implied consent to the defendant, and the defendant refused to give blood for his testing, but then officers then obtained a search warrant for his blood. As to the following too closely, officers determined that the defendant was following too closely the victim's vehicle due to when making contact with the the victim's vehicle. But when the officer made contact with the victim stated that she was traveling northbound on Highway 85, and when she was stopped at a red light, and as the red light turned green and she was about to accelerate, she noticed the defendant's vehicle approach her vehicle from behind at a high rate of speed and then collide with her rear bumper. As to count one, I also want to place on the record that the officers, after obtaining the blood search warrant, they transported the defendant to the to Southern Regional Medical Center, where nurses were able to draw his blood, and the BAC from this case is a 0.168. As to count one, the state is recommending 12 months to serve 1 day, credit for the time served. The balance will be probated for the defendant to complete a risk reduction program, complete a drug and alcohol evaluation, and follow any recommended treatment. The defendant is to have no drugs or alcohol and is subject to random screens and tests. The defendant is to complete 40 hours of community service and pay a $300 fine. Count two will merge, and count three will be a $100 suspended fine.
All right, Mr. Lynch.
Judge, just a couple things on behalf of Mr. Oluwasesan. So I believe that in the time that's elapsed since this arrest, he has made some positive changes in your life, in his life, which he kind of explored with me, and I do not believe he will be getting another DUI. As far as allowing him to do mail-in reporting and deal with, sending in specimens, I do believe, or drug tests and everything that's needed to stay in compliance, I do believe that he will be able to navigate that, because he has shown diligence in dealing with me and trying to make sure he knows everything he needs to do. I would ask that you allow him to report via mail or phone, email, whatever the probation office has in place to make that work, to facilitate him being able to not have to come back to Georgia while he is in compliance. And other than that, Judge, I am asking the court to accept the recommendation from the state in this matter.
All right, Mr. Oluwasesan, it's going to require that when probation contacts you and tells you you need a test, you go to the nearest testing facility and make sure that that information gets sent. Make sure you also send in proof of having attended each of the courses that's required. Pay the fines and fees as required in order to stay in compliance to continue phone and mail report. So as to count one, I'll accept your plea of guilty. I'll sentence you to 12 months to serve 1 day credit for time served. Balance will be probated for you to take a risk reduction course, a substance abuse evaluation, and any treatment that might be ordered. You're to have no alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and illicit drugs. You'll do 40 hours of community service and pay a fine in the amount of $300 plus the surcharges as required. And you can do so on phone and mail report as long as you are in compliance. Do you understand?
Yes, Your Honor.
Okay, and as to count 3, it's a $100 suspended fine. Count 2 will merge with count 1. Mr. Oluwasesan, I'm going to put you in a breakout room with our probation expert. She's going to get you signed up for probation. She's going to answer any questions that you might have regarding probation. Ask any questions that are specific to your situation, and she can help you figure that out, or she can direct you to your probation officer once you are assigned. Did you have any questions for your attorney or for the court at this time?
No, Your Honor.
All right, so Mr. Oluwasesan, we've finally gotten this case resolved. Please, please, please be mindful and learn from this, and let's not have this happen again, okay?
Okay. Thank you, Your Honor.
Thank you. I'm going to put you in a breakout room with Miss James. Once you've spoken to her, you do not have to come back to the main room, okay?
Okay.
Thank you. All right, next is Christopher Samaj Reed. That's also Miss Berry's case.
Madison Gibbs for Miss Kimberly Berry.
Yes, ma'am.
Hello. Hey, and Mr. Reed is on the line as well. We are requesting the case to be reset for us to get video to particularize any motions that we may have.
Okay, have y'all requested it?
I will stop by the office today to sign the waiver to get the a copy of the video to us.
Okay, because y'all file these motions, and I get that they're the omnibus, let's file them to cover ourselves motions. But at some point when you file the motion, if there's video out there, you got to request it. So why are we just requesting it when this has already been continued from one motions calendar?
I understand, Your Honor. I think there was some confusion with our office as to whether or not we had the video. But I understand that I need to go in and sign a release form in order for us to get the video, because we got the paper discovery back at the end of April, and we just need the video before we can waive any kind of motion issues that we may have.
I get it, but it's woefully inefficient.
I understand.
All right, the case will be continued to before trial.
What about the previous case, Ms. Kimberly is on, and she answering that case also?
Yeah, what's for the case of Elder? Are you
Yes.
responding on behalf of Ms. Berry for that too?
Yes, Your Honor. For Julie Elder, that will be a plea. We received an offer last week from the state, and we just need we have a counter offer to provide and some treatment documentation. So we're in the process and we're close to a resolution. Could we be placed on a plea calendar?
Did you want to talk to the state today?
It's more emailing all of the treatment that she's completed for the prosecutor to consider.
Ms. Vera?
Do we want 2 weeks or one? If we do in 2 weeks, then we could do July 7 at 10 a.m. plea calendar.
Okay, July 7, 10 a.m.
July 7 at 10 a.m.?
Yes.
Yes.
Okay. Yes, Your Honor. She will be present. Is it virtual?
Yeah, I believe it is.
Okay. Yes, Your Honor. She will be present for that to plea and close the case, and we will file any particularized motions within the next, as soon as possible for Mr. Reed.
All right, thank you.
May we be excused?
You may.
Thank you, Judge.
Next is Sura, Marcos Antonio Sura.
Good morning, Judge. Kevin Mooney for Mr. Sura. Mr. Sura is also present in the courtroom.
Okay.
And there's a courtroom interpreter.
All right.
We are prepared to continue with the motions that began last month. We would object to them being done virtually. We want to be able to exercise the Sixth Amendment right to cross-examine the state's witnesses in person in the courtroom.
Okay, that objection would have been helpful last month when we had the technical difficulties, but to tell us today.
Well, Mr. Stein did actually say in person at last month when the difficulties took place, and I was looking at the transcript that we just got last week, and literally he said, when the court discussed resetting it to next month, that it should be done in person.
He said it should be done in person. What did the court say?
Failed to really address it. Just looking at what the discussion was in the transcript, it following the first officer's testimony and then the attempt at the second one, it then became a question of I'm just trying to find where it was now, Judge. Take me a second. Here we go. As the court was discussing with Officer Christian, or former Officer Christian, are you seeing me? Is the audio bad? We can't see you. Mr. Stein says, Judge, perhaps we should postpone this and have Mr. Christian come in person. And the court's response was, yes, that's fine. That was
Okay,
on
does the
page
state have
15.
Mr. Christian in person?
Good morning, Judge Investigator Curate. I believe he was going to be here on Zoom, but I will get him on the phone right now.
I tell y'all what, let's move this to before trial. This will be on the trial calendar. And we'll do the motion to suppress. We'll finish it on before the trial calendar.
That's fine, Judge. And I didn't
That
know
way
if
everybody will be in person.
didn't know if the state had any other witnesses they plan to present.
Yeah, everybody will be in person on that calendar.
Because we did raise several issues not involving the police officers that I don't know that the state was prepared to.
Okay, so if you have other issues, y'all start discussing it. If y'all can't work it out, let me know.
Will do. Thank you, Judge.
All right, thank you.
May you excuse.
You're welcome. You are.
Thank you, Your Honor.
Your Honor,
Yes.
may I request that I be placed in a breakout room with Miss Tanya Johnson, and I think we should have a plea on that matter very shortly.
Okay. You have your device on?
I do, Your Honor.
All right. Thank you, Ms. Mendez Porter. All right, Ms. Johnson, I'm going to put you in a breakout room with Mr. Lynch.
Okay.
Breakout room number 3. All right, ladies and gentlemen, we'll get started on the 11 o'clock calendar in a moment.
Good morning, Your Honor. This is Mr. Bug. Could I be placed in a breakout room with Mr. Cole?
Is Mr. Cole from the 11 o'clock calendar?
Yes, Your Honor.
Okay, hold on. Oh, I see him, Mr. Martell Cole. All right, I'll put you. So Mr. Bug is in breakout room number 5. Mr. Cole, I'll put you in breakout room number 5. Did you need? Did you need anybody else in that room, Mr. Bug?
Ms. Brown's in person today, Your Honor. I'll try to introduce you to her later on in the calendar.
All right, thank you.
Thank you.
All right, you should see it pop up. All right, when the attorneys come out of the breakout room, we'll get started on the 11 o'clock.
Your Honor, could I actually ask the court to place the courtroom in the breakout room with Miss Johnson? I was just about done, and I think I can tell her what I need to tell her in this setting to save some time.
No problem.
I think she's probably still in the breakout room wondering where I am.
Done.
Judge, Ms. Johnson was not in that particular breakout room. I don't know if somehow she got bounced from the
Was
meeting.
when I put you in there, she still Tanya Johnson. She was, the light was green when I put you in there.
Oh,
So Miss Johnson, are you back?
Yeah, I didn't know what happened. I had waited in there, so
I know.
yeah.
I think
sorry.
his device didn't connect. So I can put you both back in there if you want.
Please, Judge, and then we'll be ready to go forward. I just need like about 2
All
more
right,
minutes.
Miss. I'm gonna move you to breakout room number 1. Breakout room number 1.
Sorry to have to deliver that news, Mr. and Ms. Strong. It seemed like you were very happy at the thought of
Back on or wave a little confidentiality here. Your Honor, I'm not sure if Ms. Adams is ready, but we are ready to go forward with a negotiated plea. for Ms. Johnson to the amended charge of reckless driving.
Ms. Adams, you ready?
Yes, Your Honor, I am ready, and I believe I've done the amendment. Yes, I have.
All right. All right, Ms. Johnson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So, Ms. Johnson, you're before the court for 2025 CR 06648, DUI drugs, count 1, speeding, count 2, too fast for conditions, count 3. You're represented by Attorney Owen Lynch with the law firm of Lister, Holt, and Dennis. My understanding is this is an amended accusation. Mr. Lynch, Ms. Adams, what's the accusation been amended to?
It's been amended to reckless driving for count 1.
Okay. All right, Mr. Lynch, what does your client plead to the offenses before the court? Reckless driving as amended, count 1, speeding, count 2, and too fast for conditions.
Judge, we're going to ask the court to take a no contest plea if there's no objection to reckless driving, just to save the points for her license on that one.
I don't usually do that.
Well, Judge, she is prepared to go forward a guilty plea if the court is not going to accept a no contest plea.
All right, guilty plea. Does she want to enter a no contest plea for speeding?
I believe the state's only requiring a plea to count or to the reckless driving.
All right, counts 2 and 3 will be no pros. By entering a plea of guilty to reckless, Ms. Johnson, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right, factual basis recommendation, please.
Your Honor, on October 30th, 2024, at approximately 11 a.m., officers were on general patrol in the area of Tar Boulevard and North Main Street, in Clayton County, when they observed the defendant's vehicle traveling at 64 miles per hour in the 45 hour zone. Officers initiated a traffic stop on the vehicle. When officers approached the defendant, the officers smelled an odor of marijuana coming from inside of her vehicle. The defendant informed the officer that she had smoked cannabis less than 1 hour prior to being pulled over by the officer.
Okay.
As to count 1, the state is recommending 12 months to serve 1 day. Credit for the time served. The balance will be probated for the defendant to complete a DUI drug risk reduction program, 40 hours of community service, a $300 fine. The defendants to have no drugs or alcohol and follow any recommended screens and tests, or excuse me, no drugs or alcohol and subject to random screens and tests. And the defendant is to have a substance abuse evaluation and follow any random screens and tests. The remaining counts will be dismissed.
All right, Mr. Lynch, anything on behalf of Ms. Johnson?
Judge, I have, well, I'm asking the court to accept the plea as negotiated. Ms. Johnson was very cooperative with the officers in this case. Judge, she has no issues with the conditions. I think she'll get those completed expeditiously. I have counseled her. She She understands she's not to consume alcohol or drugs. She currently is under a doctor's care and has some medication that she will disclose to the probation office. Judge, we're asking the court to consider that if she gets all her conditions completed as expeditiously as I think she will, to consider allow her to go on non-reporting if her drug screens are clean. But other than that, Judge, we're just asking the court to accept the plea as negotiated.
Ms. Adams?
He has no objection to after a few months of clean reporting, clean screens, it terminating.
Okay. All right, so 12 months, 1 day credit for time served. Balance will be probated for you to take a risk reduction course, do 40 hours of community service, pay a fine in the amount of $300. No, that'll be $444 total with the surcharges. No alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol or illicit drugs. You'll do a substance abuse evaluation and take any treatment that is ordered. And you'll be randomly screened. If you screen randomly 4 times and you do not test positive, then you can go non-reporting if all of the other things are complete. Okay?
Okay.
All right. Anything else, Mr. Lynch?
Not at this time, Judge. Thank you for your.
All righty. All right, so that concludes the 11 o'clock calendar, the 12 o'clock calendar. I'm ready to call that.
For the 10 o'clock and 11 o'clock, Your Honor?
I'm sorry. I'm sorry. The 11, yeah, you're right. Yeah, I'm ready to call the 11 o'clock calendar. I apologize. So, ladies and gentlemen, this is courtroom 304, State Court of Clayton County. I'm Judge Tammy Long Hayward. This is the criminal motions calendar for June 15, 2025. Mr. Lynch, Mr. Bug, do you all have anybody who is an active inmate on this calendar?
Judge, I don't believe we do. I believe that the only inmate we had for today was my client, and that is concluded. And from glancing over the calendar, I believe that is confirmed.
All right. First case on the calendar is Juan Altamirano Canseco.
Ross going in that case, Judge. Good morning.
Good morning.
We have the discovery in that case. We have not filed a particularized motion. We do not intend to file a particularized motion. However, I would like to take advantage of this opportunity and be placed in a breakout room with the state at the court's convenience.
All right. So we'll put you down for a conference as soon as we are able. We'll set up the breakout room.
Thank you, Judge.
Judge Hayward?
Yes.
Yes. Am I supposed to be waiting to speak to someone else?
I'm sorry. Yes, ma'am.
Okay.
Johnson, thank you so much. I'm going to put you in a breakout room with the probation expert. She's going to talk to you about probation and get you set up. Okay?
Okay, thank you.
All right, 1 second. I'm so sorry. Thank you so much. All right. You should see it pop up. There she goes. Okay. All right, so Miss James, I'll put her in the breakout room. All right, so a conference for Altamirano Canseco. Next is Kendra Gray Beamer.
Good morning, Your Honor. Jason Monroe in the courtroom for Ms. Beamer. She is present as well. Your Honor, we would object to having a virtual hearing if we need to go through with it today. We would prefer that it be in person. I also think that we might have some discovery issues because the police report refers to written statements from the victim, but I was provided no written statements by the state. We may be able to overcome all these problems if the state would be willing to allow her to complete the pretrial diversion program. She would be willing to do that.
Your Honor, the state is going to tender a no cross for that case.
We'll accept that as well, Your Honor.
You sure? You sure, sir?
I'm not in the mood to fight about that.
Oh, okay.
Thank you.
You're welcome. So that case will be no prost. You're free to go at this time.
Thank you.
Kenesha Trene Benton. This is Mr. Schoolcraft's case. Kenesha Trene Benton. Has anyone heard from Mr. Benton? I mean, Mr. Schoolcraft?
Let me double check. Let's see.
All right, so the motions will be dismissed for warrant prosecution. Alexis Jasmine Best.
Judge, I know that reflects Lister Holton Dennis, but my understanding is Thomas Florio has entered an appearance on this case and probably had some discussions with the state about it. Please correct me
Yes,
if I'm
Your
wrong.
Honor. No, yes, Your Honor. I believe this one has been reset already. He sent us he sent everybody an email last week.
He did what now?
He sent the court an email last week. I believe that reset for this one was already approved.
Okay.
But he was recently retained last week, and he just
All right.
received delivery.
All right, next is Martell Gregory Cole. Mr. Bug was speaking with Mr. Cole.
Judge, the state made a new offer and Mr. Bug is going over that with Mr. Cole right now. So I think we'll have an announcement pretty shortly.
All right. Next is Kimmy Daly.
Judge, this was Ms. Daly. Are you present on the call?
Kimmy Daly.
Yes, Ms. Daly. Judge,
I don't see her.
I'm a little confused why she's not here. I need to give her a call. I thought I expected her to be on Zoom, but I'll confirm that. But Judge, this was just a motion to allow her to return to her residence. There's a stay away order. I don't believe the alleged, but Judge, let me find Miss Daly and then update the court. I apologize for that.
All right, did y'all have a consent on that?
I'm not aware that we do. I don't think so.
No,
Okay.
no, not again.
All right then. Next is James Daquan Inslee. That case is closed.
It was transferred to state court, Judge. It looked like it has a CR number and it's going to Garrett for arraignment on 8/5.
Oh, okay. That's not my case anymore.
Not yours anymore.
All right. Broderick O'Neill Green.
Yes.
Mr. Holden Dennis.
Yes, Your Honor. I believe we have a consent with the state in this case.
Okay.
That is correct, Your Honor, with the exception of with the request to have contact, we do not have contact with the non-biological child in this case.
Okay, so just from a practical concept, the non-biological child, how old is that child?
The non-biological child was about 2 years old. Very young.
And that child is in the custody of, I believe, the mother, Miss Green?
Yes.
Yes, Your Honor.
And he has a child who's younger than that? Or older than that?
Older. They share several children that are older than the youngest child, but the youngest child is not the defendant's biological child.
And are they currently married or divorced? Miss Green, tell me what's going on. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right, you got to speak up or turn your microphone up, but tell me what's going on. I can't hear you at all. Do you have a device that you've attached to this or? Go to your audio where it says audio. You should see it looks like an old-fashioned microphone. If there's an arrow pointing up, click on that arrow and it should allow you to select a microphone. You can do computer audio. Are you on your phone or computer? Okay, you can come in on the phone if you wish. Okay, so Ms. Green is working on her check. So while they're doing that, Bilal Ismail, I'm sorry, Ahmad Soliman Bilal Ismail.
He's present in court, Your Honor.
Judge, Ms. Tortorella previously filed a plea in bar, but my understanding is this case is going to be transferred to Jones Parker's courtroom.
Okay.
I did confirm that with Val. We wanted the opportunity to try to argue it, but it seems that this is going to be handled by Jones Parker's court.
Okay.
And I tried to get that message to you. I'm sorry.
So that'll be in Judge Jones Parker's courtroom. All right, you're excused at this time. All right, Miss Green, unmute.
What are you looking at? Yeah, they tell them about a conviction, but it's not a suspension.
All right, tell me what's going on, ma'am. Miss Green, I can't hear you on this either.
Are you in a particular?
Can somebody?
I hear you.
There you are, Miss Green. Can you say something?
Hey.
Okay, tell me what's going on.
Oh, okay. My daughter, she's not 2, she's 16. She's the non-biological child.
Okay, are y'all married?
We divorced now. At the time we were.
Okay, so you're divorced. You have,
Yes.
how old are the children that you have with Mr. Green?
12, 13, and 14.
Okay, so they're old enough to go with him. They can leave the house, walk out to the car, go see their dad, come back into the house. Okay, so it's not an issue of him having to have contact with the 2-year-old.
Oh, she's not 2, she's 16.
The non-biological child is 16. Okay,
Yes, ma'am.
yeah. Oh, she can drive. Yeah, no. Yeah, that's fine. He doesn't have to have contact with the oldest child, but he can have contact with the 3 children as long as you don't have any fear for whatever is between them, because I don't see any charges related to the children. So yeah, that's fine. So communication. Y'all can communicate like through the oldest child, Mr. Green, if you're gonna request them, that you can send text messages or call the oldest child to determine whether that's okay for but understand that she's currently the custodial parent based on whatever y'all's divorce says. So please be respectful of that. Did you have any questions, Mr. Green?
No, ma'am.
Okay. All right. This is all I say. Y'all are already divorced. This case is going to be in your rearview mirror soon. When it comes to dealing with the children, because y'all still got a few years to actively co-parent, meaning like they're still in the home, you both still need to be involved. Please remember a couple of things. One, new romantic partners should have nothing to say about what kind of contact you have between yourselves and your children, because those are your children and y'all are co-parenting, and your children need y'all to be on the same page. They don't need somebody else, some stepmama, stepdaddy, all in their ear about what's going on, because they don't have anything to do with this, number one. Number two, be respectful of each other, because remember, your interactions determine how your children are going to interact, especially how they're going to interact with romantic partners when they come of age and start choosing people. And you don't want them to make the wrong choices. You got me? So if you two show each other respect, then that's what they will be looking for when they choose. Okay?
Yes, ma'am.
All right. All right. So yeah, unless there's something I don't know, I don't have a problem with there being a modification. Miss Green, you're okay with that?
Yes, ma'am.
Okay, and Mr. Green, you're fine.
Yes, ma'am.
All right, Mr. Bugg, submit the order. Just
Yes,
make
Your
sure
Honor.
Ms. Adams approves it. Okay, y'all are free to go. Thank you.
Thank you.
Thank you.
I was going to say, Miss Green, you started over after 12. I got a one who's about to be 13. I was like, I couldn't imagine a 2-year-old at this point.
I can't imagine it either.
I got you. Take care, ma'am.
You too. Thank you.
Okay. All right. So Mr. Ismail's case is transferred to Judge SJP. Kari Lachey Kennard. Kari Lachey Kennard. That case is up for an immunity motion.
Yes, Your Honor, she's present. She's online, I'm sorry.
I see her.
Sorry, I'm here. Yes, ma'am.
Okay, no problem. We got an announcement on that. What's going on?
Defense is ready to move forward, Your Honor.
Ms. Adams?
Your Honor, we are ready to move forward. Defense motion.
Okay. All right, so this is an immunity motion for Kari Lachey Kennard, 2023 CR 03053 for battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4. Is this Mr. Lynch or Mr. Bug?
Mr. Bug, Your Honor.
All right, Mr. Bug, Ms. Kennard, and the state is represented by Ms. Brown?
Yes, that's correct, Your Honor.
Okay. All right. Mr. Bug, did you wish to begin?
Yes, Your Honor. May I start with the opening statement, Your Honor, or do you want me to call the witness?
If you want to have a brief opening statement, you can, but otherwise you can start with your witness.
Okay, we'll just start with the witness, Your Honor.
All right. Who's your first witness?
Ms. Kennard, Your Honor.
All right, Ms. Kennard, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. Now, Ms. Kennard, you don't have to tell me what y'all talked about, but have you and your attorney talked about your right to remain silent in this case?
Yes, ma'am.
Okay, and he's gone over with you your right to not offer testimony or evidence in this case?
Yes, ma'am.
All right, so you understand that nobody can make you testify, nobody can promise you anything to get you to testify?
Yes, ma'am. I understand.
Okay, anything that you say may be used by the prosecution in any continued prosecution of this case. Do you understand?
Understood.
All right, and is it your desire to give testimony in this case today?
Yes, ma'am, it is.
Okay, Mr. Bug, I find that it's freely and voluntarily given. Your witness.
Thank you, Your Honor. Ms. Kennard, are you familiar with an event that occurred on October 3rd, 2023?
Yes, sir.
Okay, are you familiar with a Amari Wright Sheely?
Yes, sir.
Okay, can you tell me what happened between you and Miss Wright Sheely during that day?
Yes, sir. It was actually that evening. Um, my brother had just got out of the hospital from having COVID, being on a ventilator. We came home with our daughter. I was in bed. I was asleep. I don't know what happened in between there, but I was awakened by Amari being on top of me, choking me, where to the point where I couldn't breathe. She was significantly heavier than me. Um, I tried to get out from her motion without hitting her. I could not. I could not breathe. I stated numerous times that I couldn't breathe. To get her off of me, and I guess this is where I was charged with it. I don't know, but I had to bite her arm. I bit her arm to get her off of me. Once I got her off of me, I called the police. I was on the phone with the police. I stayed on the phone with the police dispatch until they got there. I tried to get out the house numerous times. I'm in my underwear at this point, and I'm just trying to get away from what she had going on. I don't know. She was enraged. When the police showed up, oh, okay. Do I keep going? Or you want me to
Oh,
say
you
I'll
can
take
take
a
a
break?
break. I'm sorry, my computer was on. Um, Prior to her putting her hands on you, what were you doing at that time?
I was asleep, sir.
Okay. Did you have an argument with her before you went to sleep?
No, sir. It was a celebration. We celebrated my brother being alive.
Okay. Did she tell you later on why she was upset with you this day?
I don't know. I think she had looked through my phone while I was asleep or something of that sort.
Okay.
What was the nature of your relationship with Amari?
We were actually married at that current moment, ma'am.
Okay.
Are you all still currently married?
No, sir. After this arrest, I filed for the divorce. I believe it was granted last year. Um, to be final
Okay.
in the Clayton County Court.
Okay. And you mentioned biting her. Would you have bit her if she was not choking you?
Absolutely not. Absolutely not. I'm a truck driver. This is what I do for a living. I'm a upstanding citizen. I don't do the domestic stuff. That's why I left thereafter.
Okay. And did you inform the police officers about what happened?
Yes, I actually did inform them. They didn't listen to me at all. I told them I was the one who called the police. I told them I stayed on the phone with the police dispatch until the police got there. And it just was I don't know. They took me to jail, man.
Okay. Thank you. No further questions for this witness, Your Honor.
Cross-examination, Ms. Brown?
Your Honor, I'm actually gonna handle this one.
Cross-examination, Ms. Adams?
Yes, Your Honor. Ms. Kennard, you bit the alleged victim, correct?
Yes, ma'am.
And that bite was intentional, correct?
In self-defense, yes.
Was the bite intentional?
To get her off of me, yes.
Okay. You claim that the defendant that you awoke to the defendant or excuse me, to the victim attacking you?
I was awakened by her on top of me, choking me, yes, ma'am.
At any time before you bit her, did you attempt to leave the room?
I could not get up. She was literally on top of me, choking me. Her whole body weight on top of me, literally sitting on top of me.
Before the argument occurred, you said that y'all had been celebrating, correct?
There was no argument, ma'am.
Or excuse me, before the altercation occurred.
Yes, my brother had been in the hospital for 3 months with COVID on a ventilator. That day he had got out of the hospital. It was his birthday. And yes, we were out celebrating and we had got home with our baby and me and my baby went to bed. And that's how I was awakened, ma'am.
But when y'all were celebrating, y'all had been drinking? Were
No,
y'all
ma'am.
drinking? No
No,
drinking
ma'am.
at all?
No, ma'am.
Okay. Um, no further questions, for this, witness, Your Honor.
All right, any follow-up, Mr. Bug? Any redirect?
No, Your Honor.
All right. All right, Ms. Kennard, you can stay on, of course, but you're effectively off the witness stand at this point, okay?
Thank you, ma'am.
Mr. Bug, did you have any other witnesses to call?
No, Your Honor.
All right. Does the defense rest in this motion?
Yes, Your Honor.
All right. Does the state have a witness to present?
No witnesses from the state, Your Honor.
All right. Argument?
Yes, Your Honor, briefly. In this case, Your Honor, the defense bears the burden to prove that justification was necessary by preponderance of the evidence, or in this type of motion. Here we've only saw one version of the events. She claimed, the defendant claims that she, or rather the defendant admits that she bit the victim, and she claims that she did so in self-defense. At this point, the defense has not presented sufficient evidence to establish that her use of force was justified. We see that there is a factual dispute, or regarding what occurred, but as noted by the officer's decision of who was the primary aggressor versus the version of the events that were told at today's hearing. And I would just submit that the evidence that was presented today was insufficient to meet that burden for immunity.
Yes, Your Honor. The defense would contend that we did meet the burden, Your Honor. There was evidence produced today that the defendant was being choked while she was sleeping, and that evidence has not been disputed by the state or any evidence presented by the state. It would likely be considered reasonable, Your Honor, to defend yourself by biting someone if they are choking you while sleeping. The defendant, Ms. Kennard, did not go any further than that one act to separate herself and get out of the house. She did not further any violence towards the aggressor. And that has been laid out here today. The state had an opportunity today to either bring the alleged victim or the officer who responded to this situation, and neither are present today. So based on the record, we would ask the court to grant the immunity motion and find that Ms. Kennard is immune to the charges against her today.
Right. Mr. Bug, Ms. Adams, as you all know, the law states that one witness is sufficient to establish a fact if believed. In this case, Ms. Kennard was sworn. She had given up her right to remain silent under the Constitution of the United States, and she offered testimony that this court finds to be reasonable based on the circumstances that she established. In addition to that, she stated that she was the one who called the police, which is verifiable. The state has the opportunity to present that information if they wish to, based on the information present for the county's records with the 911. So she stayed on the phone. She attempted to get out of the house. She tried to avoid the situation, but as she stated, she woke up to being choked with somebody sitting on her, and she was unable to defend her or to get away with the exception of biting the person. And she admitted that she bit them, and it was an intentional act, but it was an act taken in self-defense after being attacked in her sleep. So the court does find that that is reasonable. It meets the standard, and the immunity motion will be granted. Right. All right, Ms. Kennard. Ms. Kennard, I find that your all of your actions were reasonable. When I talked to you and I said, "Are y'all still married or involved?" and you said
No,
no.
man.
As
Done.
soon as
I
that
never went back to
happened,
the house. I moved out.
I took
I was
steps to
everything.
yeah.
Yes.
And that's kind of different than what I usually see, because a lot of times people don't separate themselves from a situation that I say anytime a situation ends me up in jail, that's probably not one I need to be involved in going forward. And you are the rare person who actually acted on that.
I had to get out of there, man.
I got you. So yeah, and I always say that anytime somebody feels like they got to go through your phone, your relationship is already broken. Your relationship is already broken at that point. So no need to continue from that point. I wish you well, ma'am. You're free to go at this time.
Thank you. Thank you. Thank you. Thank you so much. Thank you
All
all.
right, be safe on that road. I try and tell
Yes,
people
ma'am.
all the time.
I had to come inside to get this done. I didn't want to be
That's
in that
okay.
loud truck.
People will tell you, I fuss all the time. Do not mess around with trucks. Give them the room that they
Yes,
need.
ma'am. I appreciate it, Mr. Bug. I appreciate you, Mr. Lynch. Thank you very much.
You're welcome.
All
Have
right.
a great day.
All right. Have a
Take
great
care.
day. Bye-bye.
So Coretta King Braswell, this is a TK case that was, I guess it was going to be sent to, no, it was a NOLO plea, and they're asking for a new court date. Not sure why.
I read that hearing. It's essentially a motion to withdraw plea.
Yeah. Is she present? Coretta King Braswell?
Not in the courtroom, Your Honor.
Last call for Coretta King Braswell. All right, so that motion will be dismissed for want of prosecution. All right, the next thing on the calendar is Rasheem Buquan Williams. Mr. Holton Dennis.
Judge, Mr. Williams is on the call. We're not going forward with that motion, so I'll withdraw the motion.
Good morning.
And if I need to submit a written withdrawal, I'll do that. Judge, I would ask to be placed in a breakout room with Miss Adams or whoever's handling that case. I think we're going to try to get it resolved today, but if we can't, we'll certainly be able to get it resolved before the next court date. But I think we're pretty close to a resolution with what's on the table. I just need to make some counter offers, I suppose, Your Honor.
All right, so here's what we have. So Altamirano Conseco, Mr. Gordon wants to speak with one of you all. Cole, Mr. Bug was speaking about with Mr. Cole, and I think he was still talking to him. And then Williams, who's handling Williams?
I will speak with the defense attorney, Your Honor.
Okay, so Mr. Lynch and Ms. Brown, I'll put you in breakout room number. Mr. Lynch, are you on, or you got to go sign on?
Well, I do have my phone.
Is anybody else in the courtroom?
So I do have Judge Miss Daly. She did appear when you first called the calendar. She was making her way to the courtroom. So I do have her. However, the court and the state wants to proceed, I can go ahead and talk to the prosecutor about Mr. Williams, or if you want to go ahead and put anything on the record about Miss Daly, just I'm here.
Let's first of all, Mr. Gordon, I'm gonna put Miss Adams, are you handling the Altamirano case?
Yes, Your Honor.
All right, so I'll put Mr. Gordon and Miss Adams in that courtroom 3, breakout room 3. I'm sorry. And then Miss Brown. So what's going on with Daly, Mr. Lynch?
Judge, just to kind of let the court know what's going on. So, and she's here to put some things on the record about this, but so basically the main goal is to get the court to allow her to return to the residence. I understand that under normal circumstances, the court would want to hear from the alleged victim in the case. My understanding, and Ms. Daly can speak to this, is that the alleged victim no longer lives at that residence, which was their marital residence. She has minor children. Not being able to return to that residence, and my understanding is that he has a job that takes him out of state, and he's currently in Virginia. I can't speak to his intent to return. I haven't been able to get in contact with him, but our main goal is to allow her to return to the residence. We also would like it to be modified to no violent or harassing contact, because they do have children and are going to have to deal with a divorce coming up, I believe is in the immediate future. But Judge,
well, the divorce has a standing order that basically modifies how, or basically sets the parameters for how they are to conduct themselves while their divorce is undergoing. They're undergoing divorce.
And I
Here's
understand.
the issue that I have. I don't have a problem modifying an order as long as I have sufficient indicia of veracity or for what's being asserted. And so if it's marital residence, the issue if for me is both of them, I can't as a state court judge make a determination that one or the other of them has a greater ability to reside in the marital residence without something saying he's abandoned it or he has ceded it to her for her to reside there while they're making these determinations about divorce. I gotta have something from him
Judge,
saying that he's not coming back.
Right. And I understand. I guess what I would say is we're not asking you to say, step into the divorce court's role and say, hey, that he has to leave the residence. But what we're asking is you to allow, even if you don't modify the contact provision, for you to allow her to return to the residence. She can testify as far as what her knowledge is about him having removed himself from that residence, but I don't have any other evidence to offer to the court because she has been respecting the court's order and not contacting him. We did make some efforts to try to get his current contact, but that was unsuccessful, Judge. So, I guess even if the court were to put something in place.
But here's the issue that I have. I can modify it, but if he shows back up, it's his home too. So I don't know. This is the issue that I have. I don't know that he's moved out. If he's just on a temporary assignment, I don't know what's going on. Raise your right hand for me, ma'am. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. Switch places with her, Mr. Lynch. So, ma'am, Miss Daly, I don't want you to talk about anything that happened with the incident that's underlying this. I just wanted you to talk about what's going on with the residence. Who owns it? What do you know about whether he's coming back or not coming back, and where you are in the stage of divorce?
Yes, ma'am. So right now with the home, since 2020.
Do you all own it, or is
yes,
y'all?
we both own it, and me and the kids have always stayed there, and I also use it to make money for me and the kids. My husband has been out of the home since 2023 traveling, and right now he's on a 10-year assignment in Virginia, so he lives in Virginia, but we both own the home, and that's why I asked Mr. Lynch, can we modify the conditions to no violent contact? So if he does return home when we do have to do the divorce, because that's why we're here today, because I told him I want a divorce, and I can't get in any trouble, and I could just call because I'm the one called the cops in this situation, and I could just call the cops but we haven't had any issues or anything, and I don't think we will have any issues because it's been months at this time, and it was just a shock for him, and I think that's what led us to here. But I do believe that it's out of his system, and when we are able to come back around each other, he will be able to spend time with the kids, and we can go ahead and proceed with our divorce. So that's why I asked for no violent contact.
That's the thing that concerns me, is that if he doesn't have any knowledge that I modify the order, And so say he comes home in the middle of the night or, you know, and you're there in the house, I don't want there to be a situation where one or both of y'all, like the police get involved and y'all come, because as far as he knows, he has exclusive use of the house by
No, he
virtue of
don't.
the,
I'm sorry, Judge.
okay, by virtue of the order that's in place. Now, um, where have you and your children been staying up to this point?
We've been bouncing from family member house to family member house. And I don't even have no money because my husband was the worker and I stay home with the kids while he go out of town. I'm telling you, this whole situation just happened because I told him I'm tired. I feel like a married single mom and I don't want to be with him no more. And that's how we hear. This whole thing shouldn't even be in the works. And my husband don't even know that the order says I can't even be home. He think I just moved out because once before I moved out on my own. And he don't even know that I can't. Right now, he think me and the kids are there at the house.
Okay. All right. Any objection from the state?
No objections, Your Honor.
All right, draft order, Mr. Lynch. No violent or harassing contact. She's able to move back into the house. It is the court's understanding that her husband works out of town in Virginia and has been on a long-term assignment, and that should he come back to the home, as long as there's no violent or harassing contact, then she and the children can stay.
Thank you, Judge.
Thank you.
All right, now, Miss Daly.
Yes,
So the Superior Court for the divorce is going to have their own rules about contact and stuff like that. Okay.
Okay.
So follow this. Once you get into the divorce process, make sure you follow the Superior Court rules. Okay. If they change anything of what I said, they go first. Okay.
Okay.
All right. But
Thank
until that point, then you can return to the house. Okay. And then as soon as Mr. Lynch gets me that order and I sign it, you can go back.
Thank you. So now I could be around my husband and I could communicate with him as long as there's no violent contact.
Yes, ma'am.
Okay. Thank you.
What I would say is, because y'all getting ready to go into a divorce and people's attitudes change, try and put as much in writing as possible.
Yeah, I know how to do it now. Now that I got caught up this time, I know exactly how to do it.
Okay.
I won't be, yeah, but.
And there are co-parenting apps too, is my understanding. So if you want to use one of the co-parenting apps, you can do that.
Okay.
All right.
Thank y'all so much.
Okay, take care, ma'am.
You're welcome. And I'm
all right. The next case, so we've addressed Daly. Do you have you're waiting on a conference for Williams. Do we have any information on Cole? Mr. Bug is still working on Cole. And Ms. Adams, you're back. So do you have anything for Marino Conseco?
We're conferencing. He's providing me something. I will have an update once I receive what he's providing me, but I think he's working on getting that to me now.
Okay. All right. And Mr. Lynch, did you want to be put into a breakout room?
Yeah, and I think the courtroom is just the deputy and us attorneys. So
that's fine.
If you just put the court in a breakout room with the prosecuting attorney here, and I'll.
All right. Is that Ms. Brown or Ms. Adams?
I think Ms. Brown said she would talk to.
Okay.
Yes, Your Honor.
So Ms. Brown, I'll put you and Mr. in the courtroom in breakout room number 1. Mr. Lynch, the courtroom's already in breakout room number 1. I'm just gonna put Ms. Brown in. All right, I'll be back.
Your Honor, I do have an announcement in regards to Mr. Williams. Okay, so I'll tell her that. Once she kind of accepts my announcement. Yeah, I just figured get out of here. I gotta ride. I have to go home work from home, so that takes 30 minutes. If I go, yeah. Anyway. Yeah, thanks, Brody. Sign prelim visits like jail visits where you the tasks. Because even when I do them, I'll do them and I'll go talk to them. But I got a bunch of other shit going on and no notes getting in that file. And I'm sorry. Yeah, but y'all need to set me up for that. I'll do it one day, go home, and I forgot to put it on. Yeah. And I'll put it on after the prelim. And that makes it really pointless to go do it. Mark already has his notes and then I'll put it my notes after he already did it. I mean, honestly, prelim visits are kind of fun. Yeah, if you need intake notes. I mean, different if you did right. Intake notes, like they were better right. Or whatever else. And I mean, I'm pretty sure if you told them, if you put a note from your intake visit and the prelim is 30 days out, which is ridiculous, and you say, hey, he wants to call this witness, we're still not calling that witness at the prelim. Yeah. You know, I mean, he said the alleged victim said he didn't do it, so well, I mean, maybe we should call witnesses at prelims, but so what I was always told with doing felony prelims, which is a little different, is like, so if you're ever doing a felony prelim, right, the victim comes and starts talking.
I'm sorry, Mr. Lynch, did you have an announcement?
I'm sorry, Judge, I do.
No problem.
So as far as Mr. Williams, Judge, we are withdrawing the motion. Just due to him being out of state, some other considerations, we're not quite there on a plea, but we are going to continue to work on that and hopefully have that resolved by calendar call.
All right, so we'll say this the calendar call. All right, Mr. Williams, you're free to go at this time, sir. Please be safe, and please remember what got you here. Let's not,
Definitely,
that was a while ago, so I'm sure that you ain't that same person.
I'm not. Thank you.
Okay, take care of yourself, sir. We'll see you then.
All right, thank you. I appreciate it. Have a good day.
You too. So,
and then I think for Cole, Mr. Bug is ready to go forward with the plea. I'm sorry.
All right.
I have a question.
Yes, ma'am.
Can we make sure, Mr. Lynch, on the two motions that you withdraw, that you filed the motion to withdraw, please?
Yes, and I'm sorry if I hadn't been great about that in the past. I will file those today.
Okay. Thank you, ma'am. So for Cole, Martell Cole, Mr. Cole, I saw him on,
yes,
there he is. All right. So Mr. Bug, are you ready?
Yes, Your Honor.
All right. Mr. Cole, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
You can put your hand down, sir. So, Mr. Cole, you're before the court on 2023 CR 02873 for DUI less safe, count one, marijuana, 1 ounce or less, count two, and distracted driving, count three. Mr. Bug, what have you and the state decided on this case?
Your Honor, we would like to plead nolo if the court will allow.
On
It's a reckless driving.
is the amendment to the count one as the reckless?
It's count 4, Your Honor, I believe.
Okay, yeah, I don't do no-los on a reckless. I'll take a guilty.
Okay, Your Honor, if the court will not accept a nolo, the defendant will plead guilty.
All right, on counts 1, 2, and 3, those will be no prost.
Yes, Your Honor.
All right, so Mr. Cole, I'll accept your plea of guilty to reckless, which is count 4 on the amended accusation. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On February 26, 2023, at approximately 3:13 a.m., officers responded to a vehicle accident at 5173 Norman Boulevard in Clayton County. Upon arrival, officers observed a light pole that was split in half and electrical wires that were lowered close to the street. They also observed that the defendant's vehicle nearby the light pole with damages to the front end. Officers made contact with the defendant, who advised that he was headed home when he fell asleep behind the wheel. Officers detected an odor of an alcoholic beverage coming from the defendant's breath and observed the defendant with red and glassy eyes. The defendant was asked if he would participate in field sobriety testing, to which he refused. And he was read implied consent, to which he refused. And I don't know if I already noted it, but the defendant also advised that when he fell asleep behind the wheel, he struck the telephone pole that was in front of his residence.
Okay.
As to count 4, the state is recommending 12 months to serve 1 day. Credit for the time served. The balance will be probated for the defendant to pay a $300 fine and to complete 60 hours of community service. And then the probation can terminate upon completion. The remaining counts will be no prost.
Okay, what I have is 12 months, 1 day, credit for time served, $300 fine, and a 60 hours of community service.
Yes, Your Honor.
Okay, so Mr. Cole, count 1, 2, and 3 will be no prost. Count 4, the reckless, is 12 months to serve 1 day, credit for time served. The fine is $300, but it'll be $444 with the surcharges, and 60 hours of community service. I'll place you on probation once you have completed the 60 hours of community service and paid the fines and fees. Then I don't have a problem with your probation suspending at that time. Mr. Bug, Ms. Adams, do you all have any problems?
No, Your Honor. I believe the state said that it can terminate at completion.
Okay. All right. All right. So, Mr. Cole, I am sure you are not the same person that this refers to. We grow, we mature, we figure things out, and we make better choices. Is that correct?
Yes, ma'am.
All right. So I'm going to put you in a breakout room with our probation expert, Ms. James. She's going to get you signed up for probation. She's going to answer any questions that you might have regarding probation, regarding your fulfilling all of the court's special conditions of probation. So please make sure that you listen to what she has to say and ask the questions that you need to ask, okay?
Okay.
All right, so I see you twice. So I see that one of your devices is in a breakout room number 5. So I can put Ms. James in breakout room number 5 to meet you there if you want to do that.
That's okay.
Okay, so Ms. James, I'm gonna move you breakout room number 5. And then once you've spoken to her, you can log off and you'll be done. You just have to get done what the court has ordered. And like I said, the quicker you get these things done, the sooner that you will be off probation. You understand?
Yes, ma'am.
All right, any questions?
No, ma'am.
Okay, so if you go on and speak with Ms. James, and once you're finished speaking to her, just go on and get started on your probation.
Okay, thank you.
Thank you, sir. Be safe.
You too.
All right, so I believe the last case that we have to deal with is
Alta Moreno.
Alta Moreno.
Yes, Your Honor. We have an update on that. The state has received the documentation that's necessary. We've learned that the has been deported and just is no longer available to answer to the charges, and that the defendant won't be returning to the United States. So we are moving to nullify this case.
Okay, all right. Thank you.
Thank you.
No,
All
I'm
right,
kidding.
Mr. Gordon, anything else?
That's all I have, Judge. May I be excused?
Yes, sir. All right, ladies and gentlemen, I don't have anything else at this time. Is there anything else pending that I should know before I close it out?
Your Honor, I have a question. When is the calendar call date for Mr. Williams' case? I'm sorry.
Miss Val, what's that calendar call date?
Everyone will get notice.
Okay, we'll give you notice. I don't think we have it scheduled yet.
Okay, thank you.
All right, thank you. All right, ladies and gentlemen. So my understanding is you all will probably get information regarding a possible concern at the health concern at the jail. So it may affect some of your clients. So please be mindful of that and speak with your superiors regarding best practices, okay?
Are we still doing jail tomorrow, Judge?
Yeah, but I'm hoping to be able to do it in the pod. So I need to talk to Major Tolbert, I think.
Okay.
All right then. Yeah, I don't want to cancel it because there's some people who may be able to get out.
We don't need to cancel because we didn't hear last week, but
yeah,
it's probably from the pod.
Yeah, so I want to talk to them about the possibility of doing it that way. If not, then I would prefer to have N95s and then maybe some antiviral spray.
That's already in there.
In the courtroom. So yeah.
Okay.
All righty. Thank you. All right, take care.
Thank you, Judge.